Hello, political scientists. Mr. Brady. We're going to talk about PowerPoint 4.2 civil rights. So remember, civil liberties is 4.1. These are freedoms for all. Civil rights are going to be protections that the government provides to certain groups based on their characteristics. For this PowerPoint, please take some notes. You will see this on your final. Important stuff. We will talk a little bit about history within this because in order for us to understand civil rights, we got to kind of know the context and how our government has changed historically with regards to allowing certain groups. There's a PowerPoint if you want to watch. It's very good. Talks about the Equal Protection Clause. So we'll look at initially securing rights for those with disabilities. So here's kind of what we'll be learning in part with relation to civil rights. I think too often we think civil rights just with regards to African Americans, Black, and they certainly are a protected group that our government has provided rights for. But other examples, women, disabled, those that have different sexual orientations. So here's our definition. Civil rights. Civil rights are protections for groups of individuals from discrimination that the government provides. These are protections the government gives based on race, origin, religion, sex, and other characteristics, ensuring equal treatment under the law. The law has to apply equally. So these protections are given to prevent discrimination from private companies, government authorities, state actions. So it's different from civil liberties. Those are protections from the government. Civil rights are protections the government gives to the groups, and the government needs to act to protect individuals. The government needs to support its citizens. So civil rights, we've gone over this slide again. This is kind of the distinction, civil liberties, civil rights. Know the difference. They are important. So civil rights is found primarily in the 14th Amendment. For me, the 14th Amendment is the most important, the most significant amendment, and largely because of the Equal Protection Clause, that the laws will apply equally to all citizens, regardless of one's background. We're going to skip the first bullet point, but please write down the second. This is with regards to protecting the disabled and what have our government provided to make sure that the disabled are treated fairly. So the best example is the Americans with Disabilities Act, ADA, and this is signed by George Bush Sr. in 1990, right? This is an act that makes it illegal to discriminate for one's employment, allowing groups to help buy goods and services and participate in government programs. And part of that is ensuring that public facilities allow for the disabled to have access in. So, for example, that ramp going down to the stadium, prior to how it is designed now, it was not ADA compliant. It was just a slope that was too steep. And as a result, if I'm in a wheelchair, that would allow me to go too fast. It could be dangerous. So if I feel that that ramp is in violation of my ADA because it is not safe for me, then I don't have access to the football field that is illegal under the Americans with Disabilities Act. And I could potentially sue the school, in this case, the school district, so that they would have to fix their ramp to allow me equal access. And they did. Now it is not just a straight shot, it's like tiered, and then it kind of levels out, tiered, flattens out, tiered, flattens out. ADA was an unfunded mandate. That is a mandate. They have to do it. And this, the government did not provide any financial help to support that. But all public facilities, schools, libraries, the DMV, police stations, they have to allow access for those that are disabled. ADA also, though, with regards to employment, you cannot be discriminated because you're in a wheelchair. They still have to consider you as a viable candidate. And then the work also has to, in public facilities, provide you access to adequately do your job. Um, so there we'll go. We'll talk about that. We'll skip that. Next, we're going to look at the fight against segregation, including the Supreme Court's decision in Brown versus Board of Education. First off, again, going over some of the history, this is going to be primarily with regards to Black or African American individuals. Dred Scott v. Sanford is the first Supreme Court case that really challenged the issue of race and whether or not African Americans, slaves, would be considered citizens. Based on the Dred Scott decision, it said that, in fact, slaves are not citizens, and therefore they're not afforded the same protections and civil liberties that our Bill of Rights ensures its citizens. So no, Dred Scott versus Sanford is not one of the 15, but is just giving you the context. So initially, 80 years into our government, African American slaves not considered citizens, not given the same protections. We do then have the Emancipation Proclamation. The Emancipation Proclamation does not end slavery. The Emancipation Proclamation significantly, just in states that did have slaves, when the North liberated and took over those southern states, those slaves now were free and considered free persons. We talked about this issue of citizens with regards to whether or not undocumented immigrants that are in the United States, whether or not they should be given some of the civil liberties. And I wanted to share this with you because it relates to this concept of citizens and what does the Constitution say with regards to citizens. If I were to pull up the Bill of Rights PDF, as I'm doing currently, you'll see that it doesn't say citizens are granted these protections. So, like, first off, let's check the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise there or abridging the freedom of speech or the press or the right of the people peaceably to assemble. Doesn't say citizens, it's the people. A well-regulated militia, now I'm reading the second, being necessary to security of a free state, the right of the people. So it doesn't specifically say citizens, which is interesting into, well, if they're considered people, then maybe this would be an argument in favor of allowing undocumented immigrants those rights. It also could have been used as an argument in that Dred Scott enslaves considered people, that they should be afforded those civil liberties. But I think that's it. This decision doesn't give them citizenship status, and in many cases, they aren't viewed as people. They are viewed as property or chattel, as what it's referred to, chattel. And just as property doesn't have rights, like I own my cell phone, that's my property, the cell phone isn't given civil liberties either. Therefore, slaves, since they're property, aren't given those rights as well. Do know these civil rights amendments. The 13th, these were passed after the Civil War as a means to protect. The Civil War was in large part fought around slavery and the issue of slavery. Individuals might say, well, I thought it was not slavery, it was a states' rights issue. I would argue, well, a state's right to determine what, right? Well, to determine that it could have slaves. Underlying the Civil War was the issue of slavery. 13th Amendment prohibits slavery, doesn't outright end slavery. There, I'll bring this up. 13th Amendment does allow for slavery. Here we go. 13th Amendment. Neither slavery nor involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted. So slavery can occur if it as a form of punishment for a crime. But to all intents and purposes, slavery is prohibited. 14th Amendment, again, my favorite amendment, grants citizenship to persons born in the U.S. and restricted states from denying due process of law, right? Those are the 4th through 8th Amendment that grant some civil liberties for those that have been harmed, and equal protection of the law. Equal protection of the law. That establishes the Equal Protection Clause, which has been used to protect civil rights of Americans from discrimination based on race, national origin, religion, gender. We went over that. 15th Amendment grants the right to vote to male African Americans, male Black individuals. Does not. It's a federal law, right? But we'll talk about ways that they get around it. I do want to recommend a documentary, and it's very interesting. It talks about, well, this notion that slaves can exist if they are imprisoned. It basically talks about how, because of that, so that white individuals could remain on top hegemonically, socially, so that they could retain their power, that we have naturally created a system, a legal system, and a judicial process system by which disproportionately harms African Americans and disproportionately sets it up so that they are incarcerated, in which case they are remaining as kind of second class citizens. Because under, prior to the 13th Amendment, slaves were less than their white counterpart. So now that slavery is in effect gone, how do we set up a system that allows white people to remain on top and slaves down? Well, the justice system, we harm them. Don't write this down. Following the Civil War or Civil Rights Amendments, 13th, 14th, 15th, the South, in kind of retribution, passes a series of laws that do, in fact, disenfranchise, harm, and creates the system where white people are still on top, African Americans are still down below. Part of that is this segregation of transportation, education, businesses, where there would be white and Black sections. One example of this came about from the Plessy v. Ferguson case. You have this individual, and this is a Supreme Court case I want you to write down. Homer Plessy was traveling on a train. The train had a white section and a Black section. Homer Plessy, who was 7/8 Caucasian, by the way, back then they had the one drop rule. So if you had one drop of Black blood, that is to say, somewhere in your past lineage, your family history, you had a Black relative, well, then you were Black as well. It didn't matter what the fraction was, it was the one drop rule. And as a result, Homer Plessy was not allowed in the white section. He sat in the white section. He was thrown in prison. He later sued, believing that the train's law of separate facilities, segregation, violated his 14th Amendment Equal Protection Clause, the law that says that the law has to apply people equally. Well, the Supreme Court ruled that this was not a violation of the 14th Amendment. It didn't violate the Equal Protection Clause, as that even though they were separate, right, a white facility, a Black facility, they were still equal. And since they were equal, that there was no harm that was inflicted on him. 14th Amendment doesn't say anything about that there can't be separate. It just says it has to be equal. So this becomes the doctrine, essentially, for the next 60 years. Separate but equal is constitutional, in which case you get lots of facilities that have white and Black only sections. Now, this will later get challenged by the NAACP, in part thanks to Thurgood Marshall. Thurgood Marshall was an African American. I believe I have a picture right here. He famously was the lawyer in the Brown versus Board of Education case. He will later go on to be the first Black Supreme Court justice. Do you know the NAACP, the National Association for the Advancement of Colored People? They take on this suit. The National Association for the Advancement of Colored People, or just that, they want to, it's an interest group that works to improve conditions for African Americans. So they challenge the segregation and from the schooling system in particular. They bring a class action lawsuit, and I do need you to know this. This is one that you got to know. Brown versus Board of Education says that separate but equal is inherently unequal, thus uh, overruling the past decision in Plessy v. Ferguson. They say that, in fact, separate but equal facilities are inherently unequal, and because they're unequal, it is in violation of the 14th Amendment's equal protection laws. So the case question, do state school segregation laws violate the equal protection clause? The Supreme Court unanimously ruled 9-0 that it does, that segregation is illegal, that separate facilities are inherently unequal. And as a result, they said that schools are forced to desegregate with all deliberate speed. Now, segregation is no longer allowed, and schools must desegregate in all deliberate speed. And I'll talk back more about that. Um, of note, this was a unanimous decision, 9-0. And this was purposely, this Chief Justice said, we are going to rule 9-0. We are going to make sure that this is unanimous, because the fact that it was 9-0 kind of allows the decision to have a little bit more weight. And if it had only been like a 5-4 majority decision, well, it seems not as strong as 9-0. And the Supreme Court knew that in this important decision that the Supreme Court must have a united front, and they must emphatically declare that segregation is illegal. Of notes, well, let me share how they came to this decision. It's pretty unique. It was primarily through this doll test, as it was done. And you have a black doll and a white doll. And they interviewed and surveyed kids from the area, white kids, black kids, and they asked them a series of questions. And they said, which doll is the pretty doll? Which doll is the smart doll? Which doll do you think you'd want to be? Which doll do you think is better? And both white and black kids said that the white doll was the pretty doll, was the better doll. On the other side, when they asked, well, which doll is ugly? Which doll do you not want to be? Which doll do you think is not as intelligent? They would choose the black doll. And what this demonstrated, and this was presented as evidence by Thurgood Marshall, that psychologically, because we have separate facilities, and because they were never equal, right? The white was always better. That at its core, being black was inferior and less than of the white one. Um, and they were able to demonstrate this by showing through kids, right, who've, grow up in this system, and they're able to determine, yes, that having separate facilities does create this unequal system within our United States. Of note, this all deliberate speed that the Supreme Court said they must desegregate, some schools took advantage of it. That is a vague term, all deliberate speed. Is that quick? Is it slow? And as a result, some schools didn't desegregate, as evidenced by the Little Rock Nine in Arkansas, right? Where you have 9 individuals challenging the Arkansas's governor's decision to not desegregate. The federal government issued a mandate. The Brown versus Board of Education, that is the law of the land. Schools have to desegregate. Arkansas chose to not to. Well, the executive branch, with its National Guard, forced those kids to go to school and really blocked anybody from preventing them. Significantly, one of the Little Rock Nine members later would transfer to Montgomery High School, where I'm from. So that's kind of neat. What else do I want to say? Oh, that at the time, this was a very unpopular decision from the public. The public still preferred segregated facilities. And that just demonstrates that the Supreme Court is uniquely suited to support minority opinion, that they don't have to do what is popular, they can do what's right. And this is what the Supreme Court did in this example. Even though it wasn't popular opinion, that the public didn't like it, because it was the right thing to do, it allowed the Supreme Court, because they don't have to worry about getting reelected. They serve for life. They can do the hard thing that is right. Um, and that's important, that I want you to know. I talked about this all deliberate speed, that many of the schools still, even though segregation exists, or were told to desegregate because it was vague, like the timeline. You get many schools that didn't uh, desegregate right away. Um, I do want to hear, and this will be our last slide. Um, Today, we have what's referred to as de facto segregation. And that's it compared to de jure, DEJURE, de jure segregation. De jure segregation is going to be segregation that exists because of laws. So under Plessy v. Ferguson, you had de jure segregation, where separate facilities because that was the law. De facto segregation is segregation as a result of social norms, nothing related to the laws. Now, the way our schools, public schools, are kind of organized in that you attend a school that is nearby your house. Well, because we have neighborhoods that are nicer than others, and the fact that minority individuals are not as likely to live in those nice communities, the nicer neighborhoods, the more affluent, they're then not going to the schools nearby those affluent areas. So as a result, in many parts of the country, you get very segregated schools, because the neighborhoods around those schools are more likely to have either the minority groups or the white groups from one. There's not a lot of kind of intermixing. And as a result, you get de facto segregation. So that segregation that exists, not a result of the law, but as a result of social norms, in that communities kind of live separately from one another. So you can see examples here. All right. We'll stop right there. I appreciate you, um, political scientists. This was more kind of a history lesson as well. Let me know if you have any questions. Um, but there you go. Brown versus Board of Education is the big one. Know that it ends separate but equal. Know that the 14th Amendment's Equal Protection Clause was the primary issue at hand, and that schools now are to desegregate, and that'll allow public facilities then to also kind of use this as a precedent to end segregation within our society. All right. Hope that helped. Remember ADA as well as the American with Disabilities Act. Thank you. I'll have a good one.